Good afternoon. Welcome to Part 4 of Tort Liability and Risk Management. This is Victoria Beal with the Ohio LTAP Center, and I think you guys all know the drill by now, if you've been on these webinars with us, that we'd want to make sure you know where the question box is. I see quite a few people who've thrown a hi or hello in there already, so just please make sure you know where it's at, because our presenter, who's Dr. Ron Eck from the West Virginia LTAP Center, he's their center director there, is excellent at answering any questions that you have. So if we don't have an immediate answer, I do download those questions and send them to him. So just want to make sure you're aware that that box is there, and we're happy to take your questions. And also in the handout panel, we have the 2 items that were previously made available on the webinars and also emailed out to you. So if you need to re-download a copy of those, they're there for you. But I believe that's all I have for right now, Ron. So are you ready?
I'm ready.
Thank you.
Thank you, Victoria. Welcome, everyone. Welcome to our 4th and final session of Tort Liability and Risk Management. I just have a few introductory remarks before we get into the material. And during this time, if you have any questions, feel free to put those in the chat box, and Victoria will relay those to me. I just wanted to remind everybody in summary that the first day we talked about tort liability, what it is, what it isn't. Then the second day we talked about the tort process, the tort claims process, and where roadway professionals may get involved in that process, including production of documents or giving depositions. We also looked at some common problem areas. And then on Tuesday of this week, we looked at some risk management principles and ideas and tips for road agency personnel. And we talked about a pedestrian case study where a pedestrian was struck in a crosswalk. We're going to go, today is entirely case studies. I have a number of case studies for you. And I would ask you, just as a review, to remember as we go through these cases, because I will ask you some questions about some of them. Keep in mind the 4 elements, or the 4 things that a plaintiff has to prove to get their case into the courtroom in front of a jury. And the first one is they have to prove or demonstrate that the defendant had a duty to the plaintiff. And as I said, in most cases for public road agencies or public agencies, that's a given. Public agencies have a duty to the public. The second element is that the plaintiff has to show there was a breach of that duty or a failure of the agency to follow the appropriate standard of care. The plaintiff also has to demonstrate or show that there was some damage or injury that was suffered. And fourthly, the plaintiff has to demonstrate that the breach of the duty or the breach of the standard of care was a proximate or direct cause of the crash. So do keep that in mind as we go through these case studies. And just one more thing I wanted to mention that occurred to me since Tuesday is that sometimes when I would teach this class in person, in that setting, you have the situation where you can interact with the participants in the classroom before the session begins, or you can overhear what participants are talking about. And sometimes before this class would start, I'd hear comments like, boy, I think we're going to learn in this class that we shouldn't try anything new or innovative on our road system. And that always bothered me, and I hope, since we're 3/4 of the way through this session today, I hope no one has that impression in their mind that they shouldn't try anything new because they're afraid of liability concerns. As hopefully you've seen, and you certainly will see today, the large majority of cases that are filed against road agencies tend to be the mundane sort of things, like they involve a drainage issue or a vegetation management issue. Or as we saw in the case study with the pedestrian last time, would you agree that was just sort of a basic blunder, if you will, of failing to follow basic design or traffic engineering guidance in terms of where you locate a crosswalk? So we shouldn't, I don't think we should hesitate in terms of trying new things, but when we do that, we should make sure we follow the appropriate design principles, if they're applicable ones, or certainly general safety principles, and make sure we document what we do and why we're doing it. You know, in the past, I used to hear, it's not really so innovative anymore, but in the past, I used to hear people would say, well, I don't want to try traffic calming in my community because that's, you know, that's something new. That's just going to be a big liability exposure. But my sense is that, I don't know that that's come to pass. I've had a few traffic calming related cases in my career, and I teach a traffic calming class. So a few years ago, I did some research on cases, legal cases involving traffic calming to put that into that traffic calming class. And it's my experience and what I saw generally in the literature was that, say, cases involving traffic calming are more often than not, say, related to maintenance. The two that I've been involved with, both involved, one involved a speed hump, the other involved a choker. But in the speed hump case, I think some of the asphalt had deteriorated and broke off and was loose in the roadway, and a motorcyclist hit it. And in the other case with the choker, it was a curb that I believe had been damaged by a snowplow. And again, there was that loose concrete material in the roadway, and a bicyclist struck that and lost control and was injured. And I would contend neither of those really related to the fact that they were traffic calming devices. I would say it was more maintenance issues rather than the fact that some new, you know, device or something had been tried. And I should mention, I guess I've had two cases, both were on private, you know, commercial or retail properties, but I have had two cases involving speed bumps. And of course, to me, speed bumps are not an appropriate traffic calming device, but we do find them on private property from time to time. But both of those cases involved pedestrians that actually tripped over a speed bump. So there is a liability exposure with speed bumps, but those, in my mind, are not appropriate traffic calming devices. But with that in mind, let's go on to the case studies. And again, we're approaching the theme, kind of what lessons can we learn from these tort claims? This will be number 2 here. Case study number 2, I call it road design and maintenance. This is a rural 2-lane roadway, and a single vehicle crash occurred one rainy night. There were 2 female occupants in the car, 2 friends, they're not related. Both were in their mid-20s, and they were fatally injured in the crash. And I'll show you some photographs, but the photographs are minus a large, or I should say a line of multiple large maple trees. The subsequent remedial measure that the road agency did after the crash was remove those large maple trees. So you won't see them in most of the photos I show. I think I do have 1 or 2 police photos taken at the scene, and you will see those trees. Neither victim had been on this road before. In fact, they both were killed, obviously, but the evidence suggested, or witness testimony suggested, that they were lost. They were looking for a party, but they never made it to the party. Because it was a fatal crash, the coroner did a toxicology analysis, but there was no evidence of any alcohol or drugs or anything in the driver's blood. Probably had this crash occurred 5 or 6 hours later, that wouldn't have been the case. But in this case, they were headed for a party on a road that they'd not been on before. Each victim's family filed suit against the local road agency, so there are actually 2 lawsuits, one for each occupant of the vehicle, and the lawsuits alleged negligent design and maintenance of both the roadway and the roadside, including those maple trees that were along the roadway. So here's a picture looking opposite the direction of the plaintiff's vehicle. The plaintiff was actually coming toward us. You can see they would be coming downhill on a relatively straight section of road. And this part of the US is kind of hilly, and so this would be more or less an unusually long straight section of roadway for this part of the country. And then if the photographer turns around 180 degrees, this is what you would see. Let me get my pointer here. Notice there is a left curve warning sign, no advisory speed plaque though. And I think you can see, well, maybe see the start of the curve here. Curve does go to the left, but notice because of sort of the terrain or the dip in the road there, drivers can't really see the curve alignment, at least from this point on the roadway. And again, remember, at the time of the crash, there would have been some large maple trees around that curve. So here's a view in the curve after the maple trees. So the trees would have been right in the middle of the ditch line here, believe it or not, right in the middle of the ditch line around that entire curve. And I think you can see it's, if I didn't say it, it's not a hot mix asphalt pavement, it's just a surface treatment, or in this part of the world, they call it tar and chip roadway. You're probably familiar with that terminology. Here's another view of the curve. Here's the ditch line after the trees have been removed. You can see, maybe you can see, it's a tar and chip surface. The other thing I'm not sure I mentioned, the surfacing was probably done improperly. And so it was a bleeding asphalt surface. There was a lot of excess asphalt at the surface. And of course, when that gets wet, I think we talked about last week, that becomes extremely slippery. And so on the night in question, I mentioned that it was a rainy night. So you had a wet, bleeding pavement. And I think there was another deficiency with the roadway. And I think you can see that even without resorting to any roadway plans or anything. Can you see that this curve has a negative or reverse or adverse super elevation? It's banked in the wrong direction. And this is one of those roads I talked about, I think, in the first day we met, where I said a lot of these local roads were never designed. They just evolved from animal paths, Native American Indian trails, and that sort of thing. And this is exactly one of those roads. So this road was never designed in the past. It just evolved and expanded and had a hard surface put on it at some later date. But so this was sort of an unfortunate perfect storm of a number of issues. We had the roadway was banked the wrong way, so it was certainly not going to resist the lateral forces. You had a bleeding pavement. You had a roadside that was lined with large trees. You had a rainy night, and you had a driver who had never been on this road before and probably was going too fast for conditions. So what happened was, you can see that the vehicle slid off the road and actually struck, I think, a couple or three trees. This is just showing one of the trees, but you can see it was a pretty serious impact, obviously. And this is the vehicle at final rest. The coroner investigation indicated that after the tree impact, apparently the victims were still alive, but the impact jammed the doors shut so that even if they were conscious, they wouldn't have been able to get out of the vehicle. And you can see the vehicle caught fire and they essentially burned to death in the vehicle. So a very sad case, and we had two tort claims as a result of that. The issues were road design, and you could see the reverse or negative super elevation issue there. That was a given. I'll throw into the road design the faulty surface treatment, the faulty tar and chip that had led to bleeding of the surface in the curve. There were, of course, fixed objects on the roadside. The large trees were literally within 18 inches of the edge of the pavement. There were also some record-keeping issues. I think I mentioned in the little example I presented on the first day of our meeting, the local road agency that had just part-time road supervisors. This was a similar sort of agency. They had part-time road supervisors who had full-time jobs, neither of which was in construction or roadway-related matters. And if you recall, I mentioned in my case study from last week, one of those road supervisors last week was pretty conscientious and had undergone LTAP training and other training to bring him up to speed in the roadway construction and maintenance area. Unfortunately, the two road supervisors in this jurisdiction weren't nearly as conscientious. In fact, they made no effort to take training opportunities or educational opportunities that arose. In fact, during deposition, the plaintiff's attorney asked one of the road supervisors, was he aware that in this particular state, the LTAP Center provided free training to local governments within 50 miles of their headquarters? And he wasn't even aware of that, which was not a good sign, because the LTAP Center in this state that publicizes that very heavily, and they make a big effort to reach out to local road agencies. And so the training or lack of training for road agencies was an issue, but also record keeping. Apparently the agency also, sometime before the crash, had hired a part-time clerical person to handle the bookkeeping and accounting and other receptionist sort of duties. And not to be critical of her, but apparently they gave her no training either, or didn't allow her to be trained with outside entities. And so there had been, I think, 3 or 4 crashes before this one where vehicles had slid off the road, and the local law enforcement agency had turned in the crash reports to this receptionist slash bookkeeper or clerk, but she just filed them. She never notified the road supervisors. So the road supervisors claimed they had no knowledge of any prior crash history on this section of road. So that's not a good situation either, obviously. And as you might suspect, rather than go to trial, the local road agency settled out of court. I believe it was about $260,000 per lawsuit. So the total was well over $500,000. What might we learn from this? Well, I keep mentioning training, but training is critical for local road personnel. And personally, I think had these two road supervisors gone to just a few LTAP classes in the area of road maintenance, road safety, this crash may not have occurred or been as severe as it was had they picked up some tips from that training. Apparently, there were also some complaints that were registered by the public that lived in the area, the residents, about the trees, that they were concerned about the trees being so close to the road. And the road supervisors, again, claim, whether it's true or not, but they claimed in deposition that they had no knowledge of these complaints coming in. So clearly they had no, I talked about last time, that having a response system where you can respond to public concerns or complaints, nor did they have a system to monitor the crash data to help identify high crash locations. So clearly not a good situation. So that's an example. Any questions on that, please feel free to put them into the chat box. Case study number 3, we might call temporary traffic control, although as you'll see, sadly, there was no traffic control involved. There should have been. I call this one sweeping mud from the roadway. I'll only be a few minutes. This was a fatal crash. A motorcycle struck the rear of a rubber tracked skid steer that had a broom attachment on the front of it, and it was sweeping mud off of a state roadway. It was not a road agency piece of equipment. It was a private contractor that was working for another company, as I'll talk about. And apparently the motorcycle struck the rear of the skid steer. The motorcyclist was launched into the air, actually flew over the skid steer, struck the pavement, and I think died instantly in the crash. But his surviving wife and family filed a tort claim in this matter. It happened early October, a few years ago. It was daylight on a state roadway in a rural area. The road was straight and level, 45-mile-per-hour posted speed limit, but it was a gorgeous day. Weather or the environment was not a factor in the case, or I should say the natural environment was not a factor. And here are some scene photographs to orient you. The bike you can see is here. The victim has been removed, but these are some of his personal effects, or maybe a blanket that was used to cover him before the EMS crews got there. But it may look confusing. So the bike was coming toward us, as was the skid steer. But I think you can see after impact, the skid steer made a 180. You can see the marks he left on the roadway here. And the skid steer operator drove back toward the crash scene. And apparently, the skid steer operator claimed he never even felt the crash. It was a witness coming the other way, perhaps in that gray pickup truck that you see there, that saw the crash, and they sort of waved down or flagged down the skid steer. Otherwise, he claimed he would have just continued sweeping the road. He was not aware of the crash. This is a little bit closer to the motorcycle. So this actual impact area was somewhere back here. Notice that there's no lights or anything else on the skid steer on the back, or I can tell you none on the front. It does appear that these are yellow lights, but actually this is just some, I guess, yellow reflective tape. And apparently this is a flash photograph because it looks like it's in the shade here. But the motorcyclist would not have had the benefit of that reflective illumination there that you see. This is the skid steer itself. You can see it was a tracked skid steer as opposed to a rubber tire skid steer, and it had the broom attachment on the front. Notice no yellow rotating or revolving light or anything on top. This is the motorcycle near the point of final rest. As you can see, there's significant front end damage to the bike. And actually, if we have any reconstructionists in the audience, there are formulas or charts or graphs that you can go to. If you know the type of bike or the make and model of the bike, and you know the amount of fork deformation, you can actually calculate or determine or estimate the speed of the bike at impact. And in fact, the defendants retained a reconstructionist, and I believe they estimated the speed of the bike at impact to be 40 miles per hour, which, if you recall a few seconds ago, I said the speed limit was 45, but their argument was, as I'll share with you in a minute, there was a big cloud of dust surrounding that skid steer, and their argument was that the motorcyclist was contributorily negligent because going 40 miles per hour into a blinding cloud of dust is not what a reasonable or prudent driver would do. So as I said, the police report noted that there was a cloud of dust that visually obstructed the roadway. The source of the mud was a access road, unsurfaced access road, serving the pad for a recently developed natural gas well. This is in the part of the country in the upper Ohio Valley here, like close to where I am, where there's a lot of natural gas development. Those of you, maybe if we have anybody from West Virginia or Western Pennsylvania or Northeast Ohio, you all are well aware of these. The region is dotted with these well pads that are drilled to, of course, develop the natural gas wells. And this one had just a plain earth access road. The driveway permit for that access road called for the first 50 feet of that road to be surfaced with stone, and for the purpose of trying to minimize this mud problem. But for whatever reason, the roadway was entirely mud. Whoever was responsible for it did not put any stone in the first 50 feet. And then, sort of unbelievable to me as a traffic engineering person, believe it or not, there were no warning signs present on the roadway. There was no shadow vehicle. And as I said, there were no functioning lights on the skid steer. This is another scene photograph looking the other way. compared to some of the other photos. The reason I included this is if you look closely, you can see how the vegetation, the grass and the weeds and the brush and such are kind of covered with a film of dust. So apparently there was a pretty significant dust cloud at the time of the crash. And of course, by the time the emergency responders arrived, that dust had settled and covered much of at least the natural things in the area. This is the road after the fact. This is after the energy company, which I'll say more about, after they put in some crushed stone. But this crushed stone was not here on the day of the crash. This was just mud. And so the mud was being tracked out onto the state roadway. In fact, there you can see, this is one of the scene photos again. You can see, unfortunately, the officer who took the scene photos didn't get a shot of the road, but the road is here, and you can see, I guess, the trucks associated with the well development were proceeding in this direction, and they tracked the mud onto the roadway. And then this is just a close-up. This is one of the energy company trucks. You can see some clods of mud on the pavement, but also you can see, if you look closely at the tire here, you can see quite a bit of mud on the tire. So apparently this pickup truck had been on the well site, and you can see how the mud would be tracked onto the public roadway. The defendants were what I'll call the energy company. That's a made-up name. There might be a company by that name, but this is just a hypothetical or fictitious name that I made up. But we'll call them the energy company that developed the gas well, including the well pad, as it's called, and the access road. And they would be considered the deep pocket in this case. It's a very large company, national company. They have oil wells in Texas and Oklahoma and so forth. So they're a national firm. The contractor, I'll call them, had a contract with the energy company, and they prepared the pad. They leveled the well pad, and they also built and maintained the access road. And they also, as part of their contract, had the responsibility to sweep the public road. And then the state DOT was named as a defendant because they issued the driveway permit for the access road. These were the allegations of the plaintiff, that the energy company failed to comply with the driveway permit because they did not inspect the driveway in terms of requiring in terms of identifying that they didn't comply with the driveway permit, nor did they contribute to maintaining a reasonably safe public roadway because they allowed the mud to be tracked onto the public road. The allegation against the contractor was that they created a dangerous condition by sweeping a roadway with equipment that had no warnings or lights or other protection, which of course violates the MUTCD. It also violated this particular state's temporary traffic control manual. And the allegation against the state DOT was that the state failed to enforce its driveway permit. So of course, we went into the discovery process, and I've shared with you the photographs. There was also the driveway permit was produced, as well as some deposition testimony. So I'll kind of summarize the deposition testimony. And if you're in the roadway field or roadway safety like me, I think you'll probably find some of this disturbing. At least I did. The driveway permit was issued to the energy company on May 23rd of 16. If you recall, the crash occurred in early October. So the crash occurred, maybe 4 or 5 months after the driveway permit was issued. And as I said, it called for the energy company to keep the surface of the state road clear of mud. And in doing so, they needed to follow the state's temporary traffic control manual. The contractor, the construction company, built the road in June of 2016. But interestingly, October 4th, 2016, that is the date of the crash, was the first time the state road had been swept. So what's that, about 4 months or more, they had not swept the road. This was the first time that skid steer was out on the public roadway sweeping it. Deposition testimony. The energy company representative and I don't mean this in any negative way, but this person was not an engineer. His background was business and management, and that was his education and experience. I say that only because I probably wouldn't expect him to be familiar with, for example, the MUTCD or some of those other roadway related criteria and so forth. But he said he was not aware of this particular permit, but he was aware of permits for 13 other access roads. And interestingly, he said that no one in their firm makes sure that employees or contractors observe the provisions of the various permits, in this case, driveway permits. And here's what struck me, because I don't know where he got this from, but it shows what sort of maybe misperceptions are out there in the world that we deal with. He stated that if somebody was sweeping a road for 15 minutes, you do not need any traffic control. So he felt that the contracting company was not doing anything wrong and not having any signing or warning or lights or anything. Then the contractor, he testified that the skid steer operated at 3 miles per hour. And he also said he didn't see any issue with operating something at 3 miles per hour on a 45 mile per hour highway. I also found that somewhat disturbing. Contractor said he had never worked on a public roadway before. And he said he would use traffic control only when, quote, there is a lot of traffic, but he could not further define that. And he said, this is a rural road. It did not have a lot of traffic, so I didn't have to do anything as far as controlling traffic. He went on to say, and again, I don't know where he got this, but he said a 45 mile per hour road would never require traffic control. And if you are only there for 15 minutes, you don't need traffic control. And he was not familiar with the MUTCD. He'd never heard of it, nor was he familiar with the state's temporary traffic control guidelines. One additional note, in this particular jurisdiction, the state motor vehicle code says that all mobile equipment designed to be operated at 25 miles per hour or less, quote, shall display a slow-moving vehicle emblem. And I think you saw from the photographs, this skid steer did not have a slow-moving vehicle emblem. And this comes from the Uniform Vehicle Code, so probably each of your states, regardless of where you're from, probably has a similar provision in the Motor Vehicle Code. So, ask you a little bit to sort of play the jury. We can't meet together as a group to deliberate, but just individually, I have some questions for you, and you can maybe type some short answers in the chat box if you want to. But do you think these claims, the allegations that are made by the plaintiff, do they satisfy the 4 elements for a case to reach the courtroom? Yes or no? And what do you think are the strengths of the plaintiff's case here? And what would be the weaknesses of the plaintiff's case? And then I'd like you to also think about responsibility. If you were a juror in this matter, how would you proportion responsibility among these parties, the plaintiff? And this is, let's assume this is a comparative negligence state. So if you find that the plaintiff is more than 50% responsible, remember from last week, I believe we talked about it, if the plaintiff's more than 50% responsible, they don't recover anything.
Hey, Ron.
Yes.
If anyone would like, I could unmute them and then they could respond, through the audio.
Sure, that'd be great if somebody wants to do that.
Having to type it all out, just use the raised hand function. And when I see you raise your hand, I will unmute you, and then we can go ahead and have you respond to that. And if you're trying to recall what the 4-part test is, it's in the chat box. I put that in there for you guys earlier. So my torts professor, go ahead.
Sorry, Victoria.
I was going to say our torts professor told us we had to know what these elements were. Somebody woke us up at 2 o'clock in the morning.
I'm sure.
Quick, tell us.
And so remember, the three defendants are the energy company that developed the gas well and the road, the contractor who was sweeping the road, and then the state DOT who issued the driveway permit. And the allegation against them is that they failed to enforce the permit.
There's a question someone would like to know. Was there a record of any inspections by the state of the driveway permit?
No, no record.
Okay.
Good question, but there was no record.
Looks like nobody wants to be daring and raise their hand.
Yeah, I'm interested to see what you all think, because I do this with different groups, and it's interesting. You know, if it's a non-roadway group of people, they'll tend to come down hard on the defendants. But if it's in roadway audiences, like we probably have here primarily, they tend to come down hard on the plaintiff. So I'm interested to see what this group might think.
All right, somebody please click to raise your hand so I can unmute you. And no takers. Well, why don't you back up one slide, Ron, and maybe I'll take a stab at it. It's been a while.
Okay.
So I'm thinking, the duty definitely existed because at least on your, roadway agency and then the contractors, that they, were responsible for that roadway, and they breached it by leaving the dirt out there, which was a cause of the harm suffered by the motorcyclists, because had the dirt not been there but for all that debris being on the road, they wouldn't have been harmed.
That's right.
So, oh, here we've got some percentages somebody typed in. One person said they think the plaintiff was 10%, the energy company 20, the contractor 60, and the state DOT 10.
Okay, that's interesting.
Yeah, I'm glad they took a stab at it.
Yeah, thank you. Yeah, and to add to what Victoria said, I agree with what she said. If you take it to the contractor, to me, there was clearly a breach of the duty in operating this. This was not even a vehicle. This was a piece of equipment on a roadway, a relatively high-speed roadway, at a crawl type speed without any sort of warnings or lights or slow-moving vehicle emblem or anything like that. So yeah, to me, that the case against the contractor also satisfies the four-part test. Victoria, what do you think are the strengths of the plaintiff's case? I guess maybe we just talked about what those
Yeah.
are.
One person put in here they thought that the lack of advance notice was a major factor in the cause of harm.
Yeah, I would agree with that, certainly.
Yeah. And somebody else said that they thought the plaintiff had a duty to slow down when seeing a cloud.
Yeah, I would agree with that too. And to me, that's one of the weaknesses of the plaintiff's case. And that was going to be one of the big arguments of the defendants as well, had the case gone to trial.
They looking at the plaintiff's knowledge, the other side could dig into whether or not the person was someone who'd been riding a long time or not, because you would expect that a rider who had been riding for years would have much more experience.
That's right.
Energy company, somebody put in here, energy company had a duty to ensure the contractor knew the elements of the permit.
Yeah, I concur with that for sure. Yeah, just to add to what Victoria asked about or said, I think that the motorcyclist was probably in his early 30s, and I think his wife, of course he was killed, but I think his wife said in deposition that he'd been riding since, probably he was 17 or 18 years old whenever they could first get a license. So what's that, maybe roughly 15 years of experience?
Yeah, somebody wanted to know if the rider had a safety course on their resume.
I think his wife said he did. I think
Okay.
she testified that, to her knowledge, he did.
I know here in Ohio, we've had apparently like a loophole where someone could get a motorcycle rider's permit and never officially take the test and then just reapply and get the permit again.
Yeah,
So,
I think that happens in a few states, I think.
Did I read off these additional percentages somebody put in yet? I don't think I did.
No.
Someone else said they thought 50% contractor, 25% energy company, 15% DOT, and 10% plaintiff.
Okay, interesting.
Oh, and someone else wants to know, was he wearing a helmet? That's
I
an
believe he
excellent
was wearing
question.
a helmet, yes.
Okay.
Well, I believe that's, I'm trying to remember, but I think the impact was, I think in fact he landed on his head and the impact was just so severe that I think it shattered the helmet.
Wow. Yeah, if they weren't wearing a helmet, then I would just have argued what they call the affirmative defensive assumption of the risk.
Right.
So we've got a pretty long one in here. It says, checking a low volume road twice a year isn't out of the realm of normal, but you would hope that they would have increased the frequency since they issued a permit related to this segment. They should be monitoring it. The energy company does not appear to have done much communication with their contractor, though they signed responsibility for the permit. The contractor didn't do a good job understanding what their responsibilities were or their liability. While the rider may have needed to slow down, if it were not for the energy company pulling the permit, there would not have been a hazard in the first place. The rider may have a small amount of blame for not slowing down, but the majority seems to be on the backs of the DOT, contractor, and energy company.
Yeah, well put. I agree with most of that, yeah. Well, good input, thank you. Let me share with you what happened, because there are some interesting twists here. The state DOT before trial made a motion for summary judgment, asking to be dismissed from the case. And their argument was, it's true we issued the driveway permit, but we are not an enforcement agency, we're a roadway agency. And interestingly, the judge agreed with that, and so they were dismissed from the case. The DOT was dismissed from the case shortly before the case would have gone to trial. And actually, a day or two before trial, the remaining parties reached an out-of-court settlement. It was confidential, so I was not privy to what that was. But I think probably the energy company, I would guess, paid the most in terms of that settlement. And then one thing I didn't tell you maybe is that the investigating police officer who investigated this case, if you recall, he described this cloud of dust. He was both on the police report and in deposition, he was just outraged by the contractor's conduct. He said in deposition, how could someone operate a piece of equipment essentially almost stationary in the roadway without any warning signs or lights or a shadow vehicle or something like that? So he actually, I guess, went to the, what would it be, the district attorney, I guess, in this county, and actually they filed criminal charges against the skid steer operator. And he actually was convicted on those and served, I think, 3 or 4 months in jail. So if you remember, I said earlier, I think our first day, that a tort is not a crime, and that's true. But in this case, this skid steer operator or his company, faced a tort claim for their negligence in terms of how they were maintaining this road. But he also was convicted on criminal charges and actually spent some time in jail as a result of that. So that is out of the ordinary, but in this case, you might see that I can see how the investigating officer thought this was so egregious that he and the district attorney, or he went to the district attorney and actually criminal charges were filed. I don't know if there's any comments on that. So ended up the parties that were involved were not public road agencies. They were the contractor and the energy company. So what lessons do we learn? And you all know this, being with public agencies, I think most of you are, but we know that anybody working in or near the roadway needs to understand and follow the appropriate temporary traffic control guidelines, MUTCD or state manuals that might address temporary traffic control. And training is critical, of course, but these private entities, no one really had any training. And hopefully that training would identify that, when you're in the roadway, the vehicles and equipment involved need to have appropriate lights and warnings, and that there needs to be advanced warning when such equipment or vehicles are in the roadway. Case study 4 is an ice patch at a driveway, and I think we talked about maybe last Thursday about when I talked about some of the common problem areas. One that kept coming up was sort of drainage related issues at driveways, and here's another example of that. It was a 2-vehicle crash near a driveway. You can see in January, so kind of midwinter in this part of the country. Vehicle 1, which was a Pontiac, was eastbound. Vehicle 2, a Buick, was westbound. Vehicle 1 encountered ice in the travel lane, basically spun sideways into the opposing lane, where it struck vehicle 2 head on, and operator number 2 was seriously injured, and she filed tort claims. This is the crash scene, some scene photographs. This is vehicle 1, hard to see behind the responders here, but you can see it sort of straddling the center line. This is vehicle 2. This is the plaintiff's vehicle. It went some distance off the road, as you can see, into the yard of the home here. And the driveway is right here. This shrub is on one side of the drive. So the driveway hasn't been cleared of snow, but the driveway was affecting drainage such that there was ice on the pavement. And that's kind of the crux of the suit here, the plaintiff's lawsuit. Here's another view as they're just getting ready to move the vehicles and maybe transport the victim. But this is the driveway here, barely visible on the right. But notice there's a large amount of water and ice, both on the shoulder, on the roadside, and partially on the travel lane. It's a state highway. The posted speed limit is 45. At the time of the crash, you can see in the photos, it was sort of a cloudy day, maybe partly cloudy. Temperatures were in the low 20s, and roads were basically dry. So this is what would be referred to and what the plaintiff called in their complaint an isolated ice patch at the driveway. The plaintiff alleged that cases against 3 defendants, the state DOT for failing to maintain a reasonably safe roadway, failing to inspect the roadway, the property owner, and the allegation was that they created a dangerous roadway condition by failing to comply with the driveway manual. And a few years before this crash, or maybe the summer before, I can't remember, but anyway, a few years before, the property owner hired a driveway paving contractor to repave the driveway. And there were, as I'll show you, there were allegations that resurfacing adversely affected the drainage and created a dangerous condition, and that this contractor failed to comply with the state's driveway manual as well. They produced during discovery some photographs of the scene and the site, and I've showed some of those to you. I'll show a few more. Quite a bit of maintenance records were produced. The property owner or the driveway contractor produced the proposal and the invoice associated with that agreement between the property owner and the paving contractor. And then there was quite a bit of deposition testimony. This is also later in the day of the crash. You can see by now the vehicles have been removed, but these are state DOT crews sort of literally scraping the ice off the edge line there of the roadway. And it almost looks like they've thrown some salt down or some chemical material down there for de-icing purposes. And this is the driveway in question. You can kind of see standing water and ice here. Also, part of the issue is this ditch that you can see here in front of the truck. The road agency returned the next morning to kind of make some maybe semi-permanent repairs, or at least to get rid of this water and ice issue. And you see now they've cleaned some of the ice and snow off of the end of the driveway here. And this is one of the things they found. This was some asphalt, and it was alleged this was part of the driveway resurfacing. But what you're seeing here, and I wish there were some reference points here, but it's hard to see, but this is actually the shoulder of the roadway. So this asphalt extended out into the shoulder. And what happened, I think, again, this is not the best picture, but the drainage is flowing from the top right here to the lower left. And what would happen during periods of heavy rain or heavy runoff or meltwater, this water flowing down the edge of the shoulder here would encounter this asphalt from the resurfacing, and it was actually diverted toward the white edge line. And that was really the plaintiff's main allegation there, is that this resurfacing asphalt disrupted the natural drainage and diverted the water onto the traveled portion of the roadway. The investigating officer described the road as icy and slick and very slippery, said it was like black ice. I believe the plaintiff, elicited this testimony, and of course the plaintiff's trying to make the case that his client, the female driver that had no reason to expect this ice, she was driving carefully, and try to reduce the amount of contributory negligence that a jury might place on her. And other witnesses familiar with the road agreed with his testimony. The husband of the victim drove the road twice a day, and he said that prior to the crash, on the right-hand side, going in the same direction his wife was traveling, there was usually water always laying there. And he also went on to say he had seen water a little over that white line coming out towards the road. And of course, one of the arguments the defendants were making was, well, you were aware of this water. Don't you think you might have passed the word on to your wife, because you knew she drove that road twice a day to and from work as well? So if you cared about her safety, you would have mentioned that to her as well. And the idea being that maybe she should have been on notice about this icing condition. The owner of the driveway says that whenever there's a significant rain, water pools out in front of the driveway, similar to what you saw. And then cars drive through that and they track the water and it spreads out. I think we've all seen, all of us in northern parts of the country anyway, have seen that, and then it freezes and you have sort of a black ice condition. He had the driveway first paved in 2001, and he claimed there was a U-shaped swale to allow drainage across the driveway, and then it was resurfaced in 2008. The paving contractor says he placed 1.5 inches of asphalt in 2008 and maintained the swale. Although if you recall from the photos, I didn't see any evidence of a swale. He claims he did not place any asphalt on the paved shoulder. Of course, the photograph I showed you tends to refute that testimony. And he went on to say also that the property owner gave him no instructions about how to do the work. Also, the paving contractor acknowledged he never talked to any state DOT employees about the driveway permit requirements, nor did he read the state driveway manual. In fact, discovery showed that no driveway permit had ever been obtained, and there was never a driveway pipe under the driveway at this location, as should have been installed. The DOT maintenance supervisor acknowledged that subsurface water came out of a roadside bank and flowed down the ditch line. It's kind of hard to see, but if you can see this vehicle here in the photo, off the road there is a slight cut section. That's what I'm calling the bank. And certain times of the year, heavy snowfall or rainfall, groundwater would seep out of that bank and flow down the ditch line. So that's what he's talking about. And to orient you, So it would flow toward us, and the driveway is in this area right here. So it would flow toward the driveway. And this is the next morning. The DOT crews, you can see, did some excavation, and they're actually going to place a driveway pipe here and then backfill that, of course. But I think you can see from this photo, notice they had to hack away at quite a bit of pretty thick buildup of ice at the foot of that driveway. So again, we'll ask you for your response, either in the chat box or feel free to raise your hand. Do you think these claims against these three defendants satisfy the four elements for a case to reach the courtroom? What do you think are the strengths of the plaintiff's case? What about the weaknesses of the plaintiff's case? And then how would you proportion responsibility in terms of the plaintiff, the property owner defendant, the paving contractor defendant, and the state DOT defendant? And again, this is a comparative negligence state. So if you find that the plaintiff would be more than 50% negligent, she would not get anything in this case. So any thoughts on that?
Well, they're coming in already.
Good.
Says, one of them said, from the morning after pictures, it appears there's not proper drainage of the area. Another person said, contractor is responsible for obtaining a permit and meeting the requirements of the driveway manual. Homeowner trusts that the contractor is following regulations appropriately. State has the responsibility after issuing a permit to either inspect the work during or after. And let's see here.
Okay,
Next
good
person
comment.
said, DOT largely kept the roadway in good condition. Roads were noted as dry. Seeing that it is winter, a reasonable driver should always consider the fact that there could be ice on the roadway and drive prudently. The ice does not appear to have accumulated in the travel lane and is largely contained to the ditch and shoulder. The driver seems to have been driving too fast for conditions and is primarily responsible. And then we had someone who gave percentages, and this is not any of the previous folks who commented. This person said they felt the paving contractor was 60%, property owner 20%, the owner 10%, and the state DOT 10%.
Okay.
And if anybody wants to raise their hand, I'll be happy to unmute you.
Yeah, any other input would be appreciated. So we have a comment that maybe one of the weaknesses of the plaintiff's case is maybe they were going too fast for conditions or too fast for a 20-degree temperature day. And also that given that they live and drive in a northern climate like this, they should be aware that in January, ice is possible, probably on any roadway.
All right, so other folks must be typing, or they just agree with everybody who put comments on already. So.
Okay.
Yeah, I think the comment you made earlier about the last case study about the criminal case that was filed,
Yes.
you know, you have to remember that, you know, in criminal cases, the standard is much higher.
That's
and with
correct.
a tort liability case, the standard's much lower in the sense that it doesn't have to be beyond a reasonable doubt.
That's right.
Just,
Yeah, thanks. Yeah, thanks for that, reminding us of that. Yeah, that's a good point. Well, here what happened is prior to trial, actually all three defendants made motions for summary judgment. They felt they all should be dismissed, but the judge denied all those motions. And actually just the day before the trial was scheduled to start, a confidential out-of-court settlement was reached. Again, I was not privy to that, so I don't know what the results were. But what can we learn from that? As I think I mentioned last week, driveways can be a source of drainage issues. So it is important probably to inspect driveway locations, especially after rain or, you know, when snow melt maybe begins, once temperatures start to warm up, you know, maybe in February or March or April, depending where you are in the country, because the driveways can be a source of isolated water or even maybe sediment type material on the traveled portion of the roadway. And so we should probably be alert for changes to driveways like this resurfacing that can affect drainage patterns. So case study number 5, I think I talked about this last time, vegetation management. This falls into the category of cases that are called hazard trees. At least, I think, is that correct, Victoria? Do you know? I think at least in the legal, personal injury attorneys, I think, put this in the category of what they call hazard trees. I don't know if roadway agencies call them that, but we might want to be on the lookout, I think, for hazard trees, and we'll talk about it in this case. I'll show you some pictures, but just try to visualize it in your mind here at the start. This was a large oak tree 30 feet off the road and 20 feet up on a steep bank. And actually the plaintiff hired an arborist or a tree expert to help them pursue the case. And the arborist, I guess, investigated the remains of the tree, or took corings or borings, whatever they call it. And he estimated that this oak tree was between 400 and 500 years old. So this was an old, big tree. I mean, it was so big, two people could probably barely put their arms around the circumference of the trunk of the tree. It was a large tree. And one Sunday morning, there had been no real rainfall in the weeks before, no significant rainfall. There was no wind to speak of on that Sunday morning, but it just fell onto a car carrying 5 people, and the 3 rear seat occupants were killed. In this case, there was virtually no contributory negligence. To sort of set the stage, the driver of the car was the county school superintendent, so he was sort of well known in the community. He was probably in his mid-60s. In the right passenger seat was his wife, who was about the same age. In the back driver's side seat was the school superintendent's father, who was about 95 years old. In the rear middle seat middle rear seat was the school superintendent's girlfriend. The school superintendent's father's girlfriend, who was about 92. And in the passenger side rear seat was a mutual friend of the 2 senior citizens, who he also was about 95. So the total age of the rear seat passengers was almost 300 years old. And if you remember the case we did last time with the college student, in that case, of course, a key part of the case, I didn't really get into it since it's not a roadway issue, but a key part of that case was sort of the economic value, or damages that occurred because her life was basically destroyed. She could no longer pursue the professional career she had intended to do so. But in this case, the victims here had been retired for probably 25 to 30 years, so there was no sort of economic impact. It was more the grieving for loved ones and that sort of thing that the plaintiff, I think, was seeking compensation for. But I deviated a little bit. All 5 of them had been to church this Sunday morning, and after church, they were driving to a local restaurant to have Sunday dinner. So obviously there was no alcohol or anything like that involved. There was a vehicle in front of them, and he said that, as a witness, he said that this vehicle had been following him probably for 5 or 6 miles. He claimed he was traveling at the posted speed limit, and he said this car neither got any closer to him nor dropped farther back, so he would have to say that this vehicle was also doing the speed limit. And he said one instant he looked in his rearview mirror and he said, "Oh my gosh," because this tree had fallen on the vehicle behind him. And he just said something like, this must have been my day, because had I been a fraction of a second slower, that tree could have fallen on me. One of the issues in this case, I probably should mention, is that the day after this crash occurred, and you can imagine this is in a rural area, so if there's a triple fatality crash, this is major news. People will be talking about this. So the next day in the local paper, the road supervisor was quoted as saying, and they interviewed him on Sunday evening. He said this tree was 30 feet off the road, it's outside our right-of-way, it's the property owner's responsibility. However, it came to light during discovery that a couple decades before this crash, the road agency had actually purchased some additional right-of-way for construction of an intersection. And so it turned out that this tree actually was in the right-of-way, not on private property. So just a heads up, that one of the maybe lessons we can learn from this is that as representatives of public agencies, before we speak, we should make sure we know our facts, because that looked bad after he initially said that it was not the road agency's responsibility, but in fact, it turned out to be their responsibility. I apologize for the scan lines there, but I scanned this from a newspaper article, and so I apologize for the quality, but I just wanted to show you sort of the magnitude of this tree. This is the upper portion of the tree. The trunk is way over here out of the picture, but I think you can see it's a very large tree. The emergency responders have started to cut it up to get to the victims, but I can tell you, notice the rear of the car is basically undamaged. I think I may have a front view. Yeah, notice the front of the car is not seriously damaged either. It's amazing how this tree just fell right on the passenger compartment. And in fact, the emergency responders had to remove the roof to get to the victims. But it is, to me, uncanny how it just fell right on the passenger compartment. The school superintendent and his wife were seriously injured, but they did survive, and they've had no permanent injuries or consequences from the crash. The emergency responders cut up the tree. There was a fellow who lived in a mobile home at that location, and he offered to take the wood, I guess, for firewood. This is one of the plaintiff's photos. The plaintiff was going to show this at trial, I think mainly to show how large the tree was, but given the quantity of wood that it generated. There were multiple lawsuits filed against the road agency because there were 3 unrelated victims. So I think each of the families of those victims filed suits against the road agency. And they alleged negligent inspection, maintenance of the roadway, specifically for failing to identify and remove what the complaint called a hazard tree. And that was at the heart of the issue here. Information generated during discovery. There were a number of photographs. I've showed you a couple of those. I'll show you some more. There were the deeds with the property lines, so vegetation maintenance records, the complaint history for this section of road. There was deposition testimony. And I think I mentioned the plaintiff retained an arborist or forestry expert, and he prepared a report in this matter. But let me give you some more background here, and then some photographs. And I mentioned about the road supervisor that the tree was in fact on the road agency's right-of-way. The issues were right-of-way, inspection practices, and construction activities. And I'll use the photographs here to discuss those. Of course, the tree is not there, but this is the view from the resident's front porch. I think I mentioned that there was a fellow who lived in a mobile home across the road from where the crash occurred. This was the view he said he had every day when he left his home. The actual tree, I think, was, when it existed, before it fell, was up in this area, and then it fell. And as you'll see, that's almost a vertical slope. But can you see from about this portion here down, there's a different texture or coloration to the slide. That's because about, what did I say in this image here, about 30 years ago, I guess, 30 years ago, an intersection was located outside the photograph over here. And to maintain or to provide adequate sight lines, the road agency graded or kind of shaved off, I'll say that bank. And so that's what you're seeing there. The road agency shaved some of the earth and brush off that hillside. Originally, the plaintiff's complaint said that doing that operation caused the slope to become unstable, and that's why the tree fell. But if you think about it, that was done 30 years ago, and there was no indication that the tree or any tree on this slope was moving in those 30 years. So the plaintiff actually never pursued that allegation. But if you remember when we talked about complaints last week, I think I mentioned that in their initial complaint, the plaintiff will throw out any sort of theory, including some that they may not be able to prove in the end. And that was, this is an example of that. They could not prove that that earthwork that was done there hastened the fall of the tree. There was a resident, I told you about the resident who lived across the road. He said he lived there for 28 years and the tree always looked healthy to him. In fact, he remarked that he never even saw a dead limb on the tree. And he said, given the fact that the tree was, had it fallen, it probably would have fallen on his driveway, or at least partially on his driveway. If he had any concerns about the safety of the tree, he would have contacted the road agency, but he never did. This is a view from the intersecting road I mentioned. You can see there where the bank was shaved, I think. I used the term shaved back. The tree would have been well up here somewhere. You can see the slope is very steep, almost a vertical slope. So the tree would have been up here somewhere and fallen across the roadway this way. The plaintiff provided or introduced a couple or identified a couple of witnesses that the road agency thought were somewhat suspicious. They were female residents of the area, but they claimed they didn't know each other, but yet each of them had almost identical testimony. They were obviously, they were not present for each other's depositions, but if you put the depositions, their testimony, their transcript side by side, the testimony was almost identical, which is one thing that led the road agency to be suspicious of their testimony. And here's maybe another reason why they were suspicious. Each of them's story was that about 2 weeks before the tree fell, they were driving, and I'll come back to that, but you see this ditch here? This is the ditch they were talking about. So they're both of the women claimed that when they drove through the area, they observed a, quote, grade-all crew cleaning the ditch, the section of the ditch that you saw in that image. And I don't know about you all, but I mean, I know in public works or in construction or the roadway field, probably all of us know what a grade-all is, but I'm not sure my friends who are not engineers or public works people, I think if they were describing what they saw along a road, they'd probably call it a yellow or orange piece of construction equipment. So it just seems strange to me that both of these women would describe what was going on as a grade-all crew, which to me implies some knowledge of roadway maintenance. And each said they stopped for the guy, and I think the guy was probably they're referring to as the flagger. So it's interesting they knew what a grade-all crew was, but they didn't know the name for a flagger. But they said they pointed up to the tree and told the crew member, if you guys don't remove that dead tree, it's going to fall and kill somebody. But remember, the property owner who lived there for almost 3 decades said he never saw so much as a dead limb on the tree. And they're claiming that the tree was dead. So that, I think a number of people thought that this testimony maybe was a little bit suspicious in terms of its credibility. But let me go on to the inspection portion. This is obviously not the tree in question. This is another tree on that same slope. But if you look closely, can you see at the base here, there's some mushrooms or some fungus. I'm not sure what the correct name for it is. Maybe some of you all do. But that's at the base of the tree. The plaintiff's forestry expert said he examined the remains of the tree, and he found similar fungus at the base of the tree that fell. And then he offered 2 opinions. He said, number 1, that means there's some health issues with the tree. And I'm not an arborist, but I don't doubt that. Probably that may very well be a sign of health issues with the tree. But then he went on to offer an opinion that I thought was a little bit preposterous. And he said that, or two opinions, he said that when you see fungus at the base of a tree like that, it means the tree is going to fall momentarily, and therefore the road agency should have removed that tree. He went on to say that that fungus should have been identified through a normal windshield inspection. But remember, this tree is 20 feet up in the air, 30 feet off the road. And I'm not sure, to me, that that's reasonable that someone would identify that in a windshield inspection. I would just offer two personal comments. Number one, we can sort of study this photo, the static photo, but to me, it almost looks like that fungus is sort of camouflaged because the coloration is the same as the tree trunk and as the surrounding brush and leaves and so forth. But also remember, this is not the tree in question, of course, but this is a wintertime picture. In the summertime, there's probably going to be weeds and grasses and things growing up that I'm not sure that would even be seen in a drive-by inspection. So I don't know what you all think, but those are my thoughts. And I think maybe the plaintiff realized they had some weaknesses, that it might be hard to sell that theory to a jury. And so that's what I just told you. And so it's probably not surprising that a confidential out-of-court settlement was reached just prior to trial. But what lessons can we learn from this? Number one, as I mentioned, I would say know your facts before you make public statements. And while I'm not sure it's reasonable to expect a vegetation person with a road agency to identify that fungus from a windshield type inspection, and therefore to identify that tree for removal, to me, I think that's a stretch. But I think our crews need to be on the lookout for things like dead limbs over a roadway, or maybe an obviously dead tree that's sort of leaning toward the roadway, or other basic characteristics of hazard trees. For example, I've seen trees that maybe you all have too that actually have a hole in it where you can see through the trunk of the tree. That's clearly not a healthy tree, and if that tree is on the right of way or near the roadway, it probably should be removed. So to me, that's what I would call a hazard tree, or trees that clearly demonstrate visible health issues or the fact that they're not alive anymore, and that they could potentially fall onto or across the roadway.
Hey, Ron.
Yes.
I know in Ohio, we've had a tremendous issue with the emerald ash borer. Have you guys seen the same thing in West Virginia with your ash trees? Yeah. So that would be something that is pretty commonly known. And I know that a lot of our agencies have focused on taking trees down that have been impacted by that. So
yeah, that's a good idea to do that, definitely.
Yeah. I know that when we were just talking before the whole webinar started about derechos. And when we had a derecho come through Ohio, it was absolutely amazing to me that I couldn't get to town from out in the country because there were down trees on every road I tried to use to get out from where I lived.
That's right.
So, yeah.
Yeah, in some parts of the country, including where I live or where Victoria lives, maybe where many of you live, yeah, I mean, there's millions of trees around, and we certainly can't take all of them down, but we should be, and our crews should be on the lookout for those features of hazard trees. That might be a dead limb or an obviously dead tree or unhealthy tree. Okay, if you have any questions or comments on that, please enter that into the chat box or raise your hand. We'll probably have time just for this one, and then we'll probably wrap up. But this is another work zone case, and I call it the case of left turns against or across a work zone queue. And the issue was there adequate documentation and oversight on the part of the general contractor? This crash occurred on a Friday evening, Friday, June 11th, on a 5-lane arterial. It was a nice night. There were no bad weather or anything, but there was a work zone. and the traffic in the left southbound lane was stopped, but the right southbound lane was free flowing. I think we've all probably seen that either on, not on an interstate, this is not an interstate, or on a local road, but probably all of us have seen that. And this particular area, there was a high density of commercial driveways on both sides of the road. So there was a lot of turning traffic in and out of these driveways. And this was an angle crash. A northbound driver was turning left across the southbound traffic to enter a popular restaurant. The passenger in the vehicle turning left, there was a vehicle in the right lane, the free-flowing right lane, that sort of broadsided this turning vehicle. And obviously the passenger was not in a good location for that type of crash. He suffered a traumatic brain injury and with serious permanent physical and neurological injuries. And in terms of, I talked at the start about sympathy factor. This had a high sympathy factor. Allow me a minute to sort of visualize this. This was a Friday night. The plaintiff, or the victim, I should say, was the mother of a young woman who was going to get married that weekend. And in fact, the wedding party had been elsewhere in the community that evening for the wedding rehearsal. And they were all going to this restaurant for the wedding rehearsal dinner. And the rest of the wedding party was sitting out in the outdoor dining area of this restaurant, waiting for the mother of the bride to arrive. And so if you can picture this, the whole wedding party, including the daughter of the victim, were sitting there, a big night in her life, everybody's life, and they actually see their mother's vehicle get broadsided turning into the restaurant. And witnesses said that I believe she was actually declared dead at the scene, but they were able to bring her back to life. So it was a serious crash, and everybody witnessed this. So there was a lot of not only physical trauma, but also emotional trauma associated with the crash. Suit was filed against the road agency, the general contractor, and the traffic control device subcontractor. This is the sketch from the police report. Just quickly, I'll try to speed up a little bit. This was the restaurant. The wedding party was sitting out here. The plaintiff's vehicle was turning left. This lane had the queued up traffic. This lane was free flowing. I think there was a auto parts store, and this vehicle was operated by a young guy who was just going to get some parts for his pickup truck. And they estimated, I think he was going about 50 miles an hour down this lane when he broadsided the plaintiff's vehicle. There's his pickup truck, and you can only see a portion of the plaintiff's vehicle. And this is a daytime view. Basically, there were queues there constantly. The restaurant is sort of hidden back here, but it was almost always queued up on that roadway. The work zone had started on Monday, May 31st. If you recall, the crash was on June 11th. There's some other facts. The contract between the road agency and the general contractor required a certified traffic control supervisor on site. And they required this supervisor to report daily to the road agency, to the owner of the project, two things: the peak hour queue lengths and the crash experience for that day, if there was any. And actually, from June 1st to June 11th, there were 6 reported crashes. 5 of the 6 involved northbound vehicles turning left into the restaurant. All the crashes occurred between 4 and 7 p.m., so kind of within the peak hours. And in terms of notice, the restaurant manager had called the road agency, you can see there, on 5 different occasions. In fact, earlier on the night in question, expressing concern about crashes involving customers or people that were would-be customers, and kind of pleading with the road agency to do something about the crashes, but nothing was done. The work zone traffic control devices were apparently all in good condition and were installed according to the traffic control plan. In fact, the road agency inspectors checked the signing after each complaint and they noted in their field diaries that since the devices complied with the plan, there was no need to do anything. So no one sort of stepped back and took a broader look at this to see what might be causing these crashes. The project foreman for the contractor, the designated traffic control supervisor, was deposed. And he admitted he was not a certified traffic control supervisor, and sadly admitted he'd never had any training in temporary traffic control, if you can believe that. He was also asked how frequently he reported the queue lengths to the road agency. And believe it or not, he testified, what's a queue? So clearly he didn't have the requisite background or knowledge to be able to do the things the contract called for. And the contractor could not demonstrate that the temporary traffic control was ever inspected during the evening peak hours, which is when these crashes were occurring. This was, as I mentioned, a pretty sympathetic case. And in fact, the judge in the case tried very hard before and even during the trial to urge the contractor to settle. What I've been told is that the construction company, at the very beginning when the complaint was filed, they offered $100,000, and even up through into the trial, they offered $100,000. But this was a woman who, as I mentioned, had permanent neurological and physical injury. She'll need assistance for the rest of her life. So clearly the value of the case was well more than $100,000. But the contractor, for whatever reason, refused to settle. The result was a jury verdict for the plaintiff with an award of over $10 million. But clearly, I think you can see there were some violations of the contract. And so what we can learn from that is obviously you need to comply with the contract. Here again, we get into the need for training, work zone training, and probably the need for communication between the contractor and the road agency in terms of sharing crash experience. The road agency had the crash data and they had the complaints from the restaurant manager, but they never shared that with the construction company. And if there is a time of day crash pattern, be sure to inspect the project during those periods, that particular period of time, so you can try to get a feel for what the problems are. And make sure you can demonstrate you are complying with the provisions of the contract. And that gets into the documentation that we've talked about throughout all 4 sessions. And also, just because the devices comply with the traffic control plan doesn't mean the work zone is safe. There may be some underlying issues like there were here that need to be addressed. So I think we're just about out of time. So I think I'll stop here and ask if anyone has any questions or comments. And while you're doing that, I will just make some closing comments. I want to thank everybody for participating. I hope you found the session helpful and appreciate everyone's good questions and comments throughout all 4 classes. So with that, Victoria, I'll turn it back to you.
There was one question they asked in relation to this last case study. What changes to the traffic control should have been made to mitigate the situation? So I don't know from that picture that you can really see what they had up there for the traffic control, though, because it looks like that queue is pretty far back.
Yeah, that was the thing. The queue was far back and the right lane was always free flowing. I think after the fact, they did install the signs, and I think you all have probably seen it, that I guess they're called generally the zipper merge type of signing, wait till sort of the last point and then merge to try. I think they were trying to keep the traffic flow in both lanes to maybe discourage left turning drivers from even trying to turn across 2 lanes. But yeah, it's a tough problem because the road agency didn't want to close the access to the restaurant because that will have obvious economic sort of impacts, but it's a tough issue. And there was no real good place to sort of make a U-turn. You have drivers make a U-turn to go back in the southbound direction.
There was one suggestion that came in through the chat, and I went ahead and shared it with everybody. about a lower speed limit or speed limit with flashing monitors. So, well, I know that we are out of time, so I want to thank you so much, Ron, for the excellent series of webinars on this topic. And as you mentioned numerous times, the training seems to be a key in helping to keep you out of these types of situations. And I know with the group we have on this webinar as participants, we're preaching to the choir right now, because I see a lot of these same names at our other trainings. So hopefully they'll carry that message out and make sure other people realize how important it is to be proactive and get your training to keep you out of the courtroom. But if it does happen, at least now you understand what the process is. So thanks so much, Ron.
You're welcome. Thank you, Victoria.
Everybody have a good rest of your afternoon, and we'll see you on a future webinar. Take care.